Very well. It's 8:10 p.m. Good evening, ladies and gentlemen, esteemed participants, and distinguished guests. Welcome to our highly anticipated seminar. Today we gather with a shared passion for legal writing, seeking to reinforce and elevate our skills in this crucial domain. Our esteemed speakers for the day are Kibet Brian and Sydney Tambasi, who bring a wealth of knowledge and expertise to the table, making this an unmissable opportunity for all of us. First, let me introduce my co-counsel, Kibet Brian. Kibet Brian is an intern, and he said specifically to mention the word at PricewaterhouseCoopers, the famous PwC for all of you tax interns, and an LLB candidate at the prestigious University of Nairobi. He also made sure I mentioned that. So, Kibet. Notably, Kibet is also a regional representative in the Academic Forum of Afroeconomics Law, Eastern Africa. His accolades include CB Madan Award in 2021 and participation in the 2023 Global Trade Academy at Georgetown University Law Center on an Afroeconomics Law Scholarship. All these are a testament to his dedication and accomplishments. Next on stage, we have Sydney Tambasi. Sydney Tambasi, could you wave to the audience? Yes, that's Sydney Tambasi, a trainee advocate at the very renowned law firm Ellen Anjarawala and Kana LLP. Sydney's academic journey includes an LLB degree from the Kenyatta University School of Law, and his contribution as the lead editor of the Eastern Africa Academic Forum of Afroeconomics Law highlights his commitment to legal scholarship. Notably, he has garnered awards such as the 30th All African Human Rights Competition and was a runners up in the 12th famous Nelson Mandela World Human Rights Moot Court Competition. I know we have mooters in the room, so keep an eye for him. So over the next 40 minutes, Kibet Brand will delve into efficient and effective pre-writing techniques, while Sydney Tambasi will follow with critical insights into writing and revising techniques. Each speaker will have 25 and 15 minutes respectively. We have thoughtfully allocated 20 minutes for your questions at the end, but since most of you came late, we'll chop that off to 10 minutes. So without further ado, let's embark on this intellectual journey together. And Kibet and Sydney, the floor is yours.
Oh, thank you very much, Paula, for that very kind introduction. Thank you to Natasha Kahungi and the entire team at the University of Nairobi Law Journal for bringing in this seminar together. So thank to my good friend Sydney Tambasi for accepting to come and join me today presenting this seminar. Thank you also to the participants who have set aside some time to come and join us in this legal writing seminar. Legal writing in its own is quite noble and very eventful endeavor that you could put yourself into. And and I'd like to commence by saying that all of these slides that I'm going to be sharing on their own are topics that can take quite some time to cover. So in the interest of time is why most of these things can be discussed for quite some time, and I'll just be glossing over most of these issues. And I do hope that in the course of my presentation, you are going to tease out some of the most essential things that you could put into use in the course of your presentations. So this presentation is titled the Right Way, Maximizing Productivity and Quality in Legal Writing. And I do hope that the skills you get here, you're going to utilize them in the blogs that you are writing for the University of Nairobi Law Journal and the many calls for papers that we see from time to time. So what are the aims? What are the aims of this particular presentation? One, you seek to enhance your legal research skills, improve the legal writing techniques which you may possess at the moment, introduce yourselves to the designing of research projects, at least in our view. And finally, enhancing the quality of research outputs. While presenting all this, we are mindful of the fact that all which we are sharing with you could be what worked for ourselves. And we are also warning ourselves of the risks that we are falling into in presenting what worked for me and Sydney in a standardized manner. Why so? Because we might fall into the trap, the trap of mechanizing things that ideally should be organic in a way, you know. So you have to put that caveat in mind that this is how me and my co-panelists at Sydney view some of these things, and all of this is subject to debate and the like. So what's the scope of the presentation at hand? First, there'll be an introduction which I'll be covering. Then I'm going to look into the types of legal research outputs that can be coming from yourselves, how you are going to develop the research questions that you're trying to look into, and broadly the two limbs that constitute a legal research process. That's the preliminary research section and the in-depth research section. I'm also going to gloss over the outcomes that what is the outcome that you might look into after conducting a preliminary research and what should you do to it? And second, what is the in-depth research section or in-depth research in general, and what's the outcome that comes out of it? Then after I'm done with that particular sections, Sydney is going to come on board and look into the conceptual framework. Sydney is more of an editor here. He's going to share his perspectives through the lenses of an editor who's edited some of the renowned journals and blogs in the country. So I'm now proceeding to general introduction of legal research. So legal research is essentially a social science research. For those of you at the University of Nairobi who joined in first year, like a few years back before the restructuring, the School of Law was located in the College of Humanities and Social Sciences. So you have to differentiate the same from the College of, for instance, the Biological and Physical Sciences. And what's the fundamental difference from these two types of institutions or the two types of branches of sciences is that social sciences predominantly concerns itself with qualitative research and not the quantitative sections. It's so hard to find a legal paper that's utilizing graphs or even that requires you to go to the laboratory. Not unless, of course, it's a tax dispute somewhere where pharmaceutical companies involved, you might have to look at some of those things, but it's rare. It's so rare for you to to look into the quantitative research, as it were. So since it's mostly a qualitative research, it's something that you do in the qualitative research section. It might lead to, since it's predominantly a qualitative research, it might lead you to, from time to time, you'll have to use good sources. So good sources of materials that you might have to use include journals, include things such as podcasts and the like. So what's critical while looking at some of these sources is to approach the question that you are going to frame with a critical mindset. So what's a critical mindset? A critical mindset is one which an individual at all times attempts to question the way in which they are thinking. It's about testing that which you intend to say while using counterfactuals and the like. So it's about taking time to reflect, and it's all about really um, going beyond the question that you've been asked and really looking from the outside looking in. If somebody else, a third party, were to look at your work, what would they make of that which you are trying to say? And finally, in order to ensure that your work stands out, ensure that your work is beneficial and unique. That is, by beneficial, it means that when somebody looks into your work later on, they are able to learn, they can use it as a source for that which they are trying to do. And uniqueness is essential for the fact that if somebody else has already written on something, what's the essence of you going ahead and doing just replicating the same? Isn't that just like chasing your own tail? So to illustrate the two sections, that the two things that I've just shared, there are two sets of memes. So in the first meme towards your left, you can see the proposed work that you are presenting and how it should fit into the existing work that exists. So if you are to look at the hair of a young person which is full, like the entire head is covered with hair, then you'd say that your work should like your work should fit into the same. I hope that's pretty much self-explanatory. Then the second one presents the critical mindset with which you should approach legal research. That is, you really need to look into that which you are trying to say, like this person is doing with a microscope, and testing it with counterfactuals, counter arguments, and answering all those questions the moment all that arise. And secondly, if all you can do with your work is the bogusness with which this person is doing his work down here, then it wouldn't amount to much. So those things that you are the papers or blogs or whatever legal research that you're involved in that you're trying to come up generally fall into two broad categories. Could be descriptive or prescriptive. So descriptive papers are those ones that observe and examine a subject. They just tease out, flesh out the characteristics that they possess, and they are predominantly neutral and objective in the way in which they are communicating the same. For instance, a while back or earlier this month, I had the benefit of reading Paula Kilusi's paper, the Parklands Diary, on the Kenya's new court annex mediation rules. If you read it, it essentially gives you a gist of what the court annex mediation rules are all about. And it's objective and it does not provide her personal opinions or any recommendations on the same. On the other side, you could do prescriptive papers, which take a proactive stance. That is, they recommend strategies, they propose solutions, they analyze issues as they are. Like you look into a legal problem, you examine it, you flesh out challenges that exist with that particular legal framework or their benefits. Is there a way in which they can be made better? So those are the kind of things that an individual makes in the same. Or even in most circumstances, an individual even goes ahead and makes normative claims. That is, makes some claims which are intended to make an individual to think or believe in a certain way. So most of the time, most depending on whatever you're trying to work on, your work will fall into broadly into either of the two categories. Then once an individual has sat down and has said that they are ready to they are ready to commence to begin writing a paper or something, an individual is going to proceed to develop a research question. So essentially, a research question is that which you are trying to investigate in your work. What is this thing that you've seen out there and you're trying to find an answer to? So an individual has very rough ideas at this point on what they're trying to say, and they could have picked their thoughts from nowadays, given the could have been from a publication that you've read, could be from a conversation you've had with a friend, it could be from a podcast, could be a question in an exam or a cat that you find that you found so hard to find sources on and you're trying to answer. And also, you could even find it from a research agenda, like you could be reading through these concept notes for research conferences. For instance, I believe UNLJ did one last year. There are those themes that are rising that they would like to be addressed. So you look at one of them and you're like, I believe I can answer or provide an answer to one of these questions. So after that, or after looking into all that, an individual might proceed to go and try and flesh out a question from all that which they are going to work on in their research. So once you have your question, what happens next? You proceed the next section, which generally you can say is the preliminary research stage. So at this stage, you develop an argument or an hypothesis that you would like to make. But while doing that, you have to remember, you have to like think critically about that argument that you're trying to make. Why do you have that in mind in the first place? Why are you making that particular argument? Where is it coming from? What are the assumptions that you are making? What are the key claims of that particular argument? And once you framed all that in your mind, and it's something that you can point, you now begin reading widely on the topic. Has it been studied before? That means that you have to really try and pick good sources, and you have to pick good sources and try and read deeply on that particular issue. And most of the time, when do you know that you've read enough? Some of my friends have said that you read till you see that you are reading the same things. Like all these new things that you are reading, you can pinpoint and look back and say that I read this somewhere else. So that's when you can see that at least I have a broad or a good idea of what I am trying to say or do. So occasionally or from time to time, that which you intended to study, you might find that it's already been said or written about. So at that point, your project has technically collapsed or so. It's also important to share with you that it's essential to possess strong legal reading skills. That is, most of the time, or the way in which you've been trained, maybe the first things that you read in your life were newspaper magazines, and all that you are trying to tease out from what you are reading was the information that is being shared by the author. What is he thinking, or what is he trying to say? That's information. You are reading for information. I think while reading critically for the purposes of legal research, it is essential that you look at the question, you try to look for the question that the individual is trying to answer in the paper. Then you see, if this is the question, what is the answer that they are sharing in that particular paper? And if this is the answer, how do they arrive at that particular conclusion? So that's generally. So now you have a generalist approach to exactly how you have a general idea on the research project at hand. Then so you can see this, but some things can happen when you are doing a preliminary research. Sometimes the results you find from the same are opposite from what you thought in the first place, and this shouldn't make you as a young researcher, this should not be something that's heartbreaking. Rather, it should be something that gives you new ideas on the research that you are going to conduct in the future. Actually, it might be time to redesign your question and frame it differently. So after doing your preliminary research and you have everything, you build on your research question. So you look at your research question, you look at how it breaks into very many smaller questions that you may try to answer, so that all these smaller questions answer one big question that you are trying to that forms the skeleton of your research project. So it's important that you read quality materials on the same, and you tease out the ones that are relevant to your work. So how one would ask, how do you find that something is relevant to your work? Because there are so many materials out there, and you might not have the benefit of time to read all of them. So my approach has always been this one, and maybe I could share with you because it was equally shared by another individual who I believe is quite big in the legal research space. He said that the first thing that you do is you read the abstract. So take your time, read the abstract. Don't rush so fast to the literature review section. or where they are doing the determination and the like, where if it's a case law, try and find this particular, the first part sections of the research. The abstract, once you've read the abstract, which is pretty short, around 250 words, if it looks relevant, you go also and read their conclusion. What are they saying? How does it appear? If it fits, then you try and read the entire paper in the manner that I already shared, and you see whether it works for you. It's also essential at this point in time to take your time. Sometimes a good paper can take quite some time to build on. It's not something that maybe you can do in a day or two. And it's also important to see this, but while you're doing your in-depth research, to try and, as you read these many papers, you look at what is relevant, and don't like, it's not good for you to think that you are going to remember. It's good to put them somewhere. Maybe I could just share with you some project I was working with someone, and show you my in-depth research when I'm doing the in-depth research. Just a moment. A moment. So So you can check, you can see how my this particular in-depth section is something to do with the legal, the entire issues that are rising out of the SGR contract. And I've identified a couple of cases which I believe are going to assist me in the course of conducting my research. So you can see that I'm finding out a case, this one, edition number 58 of 2014. Then the most relevant section, at least for me from the case, is this one, the issues that were being raised that are arising from that particular case. So it's not, you can see that here I've not lifted the entire case, just lifted a very specific section that's going to build on a paragraph that's going to be found here. Then this is another one, this is another case. And you can see that I have also fleshed out that which is important for my research. So it's not the entire, like once I've read most of the case on itself, I'm proceeding to just lift that particular section here for the purposes so that it can be found in this particular section that I am working on. And finally, um, so it could be a paper, it could be anything. Just put in your thoughts and why a particular source finds itself there. For some people, you'll find that when they're doing this, it's just titles of books saying that it's this book, page this, another paragraph this, a case, paragraph number this, or just this and that. So that's just my section when I'm carrying out in-depth research. Let me go back and share the screen. Yes, so that's what I have for the purposes of carrying out in-depth research. And then, these two memes essentially share with you what I've just shared with you above. Sometimes we overestimate our powers. Say that somebody's telling you that this isn't some paper that you can just write in one night. So interesting that nowadays we have people who interact with something for the first time on an evening, and the following morning they have a paper that they are submitting for publication. Well, could be you could be that good. We don't dispute it, but I belong to that conservative group of people who believe that good legal research can take quite some time to build on, and can because I was reading a blog the other day, and it's also about the kind of materials that we use for our legal research. And the main argument that an individual was making was that I believe when he was writing the same, they were frustrated by the judicial system, particularly at the Court of Appeal. And the case that they were making was that the number of should be increased. And he's saying that the maximum number of judges in the Republic of Kenya is 10. Consider this an individual who didn't take their time to try and read into exactly what's happening in that particular court, what's the maximum, what's the minimum, and the like, because the number is saying is the maximum is actually lower than the minimum number of judges. But I'm not here judging anyone anyway. It could be true, it could be false, but believe I throw it out there for you to ponder over how it would look in your name that in the Parklands diary somebody has made such a claim which we believe is outrightly false. Then finally, before I hand over to Sydney, once you begin writing some of these things, you will find yourself, you are a young legal researcher, and everyone else is saying that I don't owe anyone anything anywhere, have no debts, sina deni ya mtu popote. But once you are deep into legal research, there'll always be someone whom you owe a draft. That could be Natasha, who's the editor in chief. It could always be somebody in the University of Nairobi Law Journal, but it could always be somebody like Sydney, who is always on our necks at the academic forum over there at the Astronomist Law. Thank you, thank you. That will be all from me at this point in time. I look forward to your questions after Sydney's presentation. Sydney.
Okay, thanks a lot, Brian and Paula and everyone else who's organized this. It's really incredible, and thanks for the wonderful presentation, Brian. I mean, it makes my part of the presentation very easy because you have captured essentially most of what ordinarily I would talk about. So I have less than 15 minutes to make an argument, and what I will do instead is to raise some provocations. I will just raise some provocations without going in depth on any one of them. The strategy here, of course, is that if I provoke you enough, you should be able to invite me next time, which would be a great privilege for me again. So just picking up from where Brian has left, he mentioned something about the research question. In other circles, we prefer to call it the central claim. The French would say the raison d'etre. I don't know how to pronounce it properly, but the main reason as to why you write the paper. So I always thought that it is the most important part of an academic paper or a research paper. But more and more, I think it's not. I think it is a prerequisite that by the fact that you are embarking on this journey or whatever you'd call it to write a research paper, I've seen a hand raised. There'll be time, I think, the last 10 minutes to ask questions. By the mere fact that you're embarking on this journey or you accept yourself to be subjected to this violence of research and reading, you should have a central claim. So in a way, it's a condition precedent or a prerequisite and not, in my understanding, the most important thing. So of course, then from where I see it, what is the most important thing? And what I think is this conceptual framework, what Brian has projected on the screen. And again, like for everything else I'm going to say, I'll just briefly speak about it. So the conceptual framework is what you could call the thread that ties the paper together. So what are the paradigms that are affecting your paper? Yeah. What are the variables that are affecting your research question? Or what are the variables that are affecting your central claim? How do they build into each other? How do they interact? How do they not interact? And in a way, each chapter, you'd call it a chapter, a paper usually has many parts, so the subtopics, as you would call them. In most papers, you'd see it's divided into like 4 or 5 major parts, like an introduction, 2-3 parts, and then a conclusion. So just allow me to call them chapters. So each of these chapters should speak to each other. When I pick your paper, and as Brian has said, you could pick a paper and go straight to the abstract. I could pick a paper and go straight to one part of the paper that is speaking to, to something I'm researching on. So for me to read that paper, I should be able to, in isolation, and then to pick another part of the paper in isolation, I should be able to see what this golden thread that we call the conceptual framework is and how it's flowing within the lines that you have written. So there has to be a relationship between the variables. One of the easiest ways I would say to identify this is we normally ask the questions how. How did this come about? Which I think for me is the most basic or the most base level question. How did we get here? How do we come to speak about this subject? And then at a bit an upper level, we start to ask why. You know, why is this happening? Why is this not happening? Why does this lead to this, and so forth? But for me, I think a deeper question that we often don't ask is who. You'd find that a lot of phenomena or social phenomena, political, whatever they are, always have what I would call a sponsor who acts knowingly or unknowingly. So if you've done, like, I think, I don't know, it's tort law or what, there are acts of omission and there are acts of commission. So by failing to do something, you have directly contributed to something. And the who is not always a person like Brian and me. It could be an entire institution. It could be the judiciary as a whole. It could be the continent as a whole. It could be an organization, the African Union. It could be a multiplicity of organizations, for instance, NGOs as a whole. So I think that's usually a good question to ask. Beyond the conceptual framework, I have in my notes this thing we call cause and effect. Cause and effect, for every cause, there's usually an effect. I think it's a scientific concept from Einstein, I believe, unless I'm mistaken, I have grievously misremembered. But for every cause, there's an effect. And for every effect, you can dig back and try to identify what the cause is. So usually when you are undertaking this research project, you start from a point of effect generally, and then in retrospect, action, reaction, action, reaction, exactly. Cause, effect, action, reaction. You start from the reaction, or you start from the effect, and in retrospect, try to find the cause. So for instance, if we are talking something like, I don't know, police brutality, we have identified this as a phenomenon, we do not like how the police are treating protesters, or we do not like how the protesters are protesting. So we've identified the effect, and then now in retrospect, we try to find the cause. The problem with this is that a lot of times we don't spend enough time to dig back, to dig way, 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 way back to find out what the actual cause is. And scholars like Suzanne Marks in her article, Root Causes of Human Rights, and Walter Rodney in How Europe Underdeveloped Africa have identified this, that the researcher often looks at an effect and then goes back a little, and then they find something, and then they say this is the cause. So for instance, if it were police brutality, they dig back and they remember 3 days ago the police claimed that they were tired and they did not like that they are being used in the protest this way, for instance. And then they say the reason why there's police brutality is because police are tired and demotivated. But just as an example, as a very loose example, it's not a subject I've studied on, so don't quote me. But what happens is that you go a few steps back, you identify a phenomenon, and you think it is the cause. Oftentimes, that phenomenon in itself is an effect, a result of something that happened way back. So the technical term for this is historicization. You have to really go back, to really dig way, 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 way back. So for instance, if you're identifying or you're trying to study the political atmosphere in the country, you have to go back to the establishment of the empire, the colony. What are the effects of the colony on the political system? You have to go back again and see, how did the pre-colonial state or the pre-colonial states interact or with this issue, or how did they handle this issue? So ideally, the whole question is a question of digging back as far back as possible to try to find out how we got here, why we got here, why what is happening, why certain phenomena are not happening. And you would introduce here things like comparative studies, and you are trying to understand, again, still within the auspices of the conceptual framework, why is this happening in Kenya and not in Uganda? Why is this happening in Nairobi and not in Mombasa, and stuff like that? Who is behind this? Who is facilitating this? Who ought to have rectified this and did not? So those are some of the provocations, I would say. So for instance, at a more technical level, I could say, if you're looking at an abuse of human rights, like I've said, I've used police brutality as such an example of an abuse of human rights. If you dig back a few steps back, you come across vulnerabilities that expose victims to these abuses. So for instance, you discover that it is people in the informal state settlements that are most exposed to these vulnerabilities. When you dig a bit back, or when you go further beyond that, you come across conditions that engender or sustain these vulnerabilities. How did it come about that only these people in this particular area are facing this abuse? Or if you're talking of femicide, how did it come about that only women, or mostly women, are facing this problem? When you go even further back, you come across a more general phenomenon, which is the larger framework within which these conditions are systemically reproduced and sustained. So there has to always be a significant element of generalization, without which I think you would often miss the point. Because what is the umbrella? What is the larger problem here? And usually we call it the bird's eye view. Without the bird's eye view, you go into what we call over specialization, or you are too focused on a certain phenomenon that you are failing to understand what the surrounding phenomenon around it are, or what the surrounding concepts, or what I called the variables, what the surrounding variables, that are affecting or interacting with this phenomenon are, right? I think the last thing I will talk about in my last 2 minutes, again, it's not a complete argument, as you have seen, it's a provocation. The last thing I will talk about is, what is your voice then as a researcher? And Brian has very well articulated the aspect of literature review and going into works that are existing, using that phenomenon photo with the hair, and what are the existing works, and what does your role play? So your role is the V, that's coming to fill in the hair, the missing hair. You've seen that photo, yeah? Oftentimes, the folly of the researcher is that you do an incredible literature review. You can just pull it up. Yeah, exactly. So that's, this is the existing work, this is your proposed work. But as I mentioned, the folly of the researcher oftentimes is to dwell so much on the existing work, in the sense that you spend a huge percentage of your paper piecing together very articulately for the more advanced researcher, that Brian said this, Gilbert said this, Leonida said this, and Jacob said this, and Valentine said this, and Amanda said this, and this is what together they are missing. And this is the shortfall of the work of Paula, or this is the shortfall of the work of Brian, and so forth. But what often misses is your own voice. What are you saying as Brian? What are you saying as Gilbert? What are you saying as Valentine and Amanda and so forth? Yeah. So when you are sitting down to write, a lot of times we hide behind the works that have been done. Because if I quoted something, and it's a famous quote from Sankara at a time when he was being questioned about his philosophies, and he was saying, look, these are not my philosophies. You should go and I'm only quoting Karl Marx, or I'm only quoting Plato. You should try Plato, don't try me. So the researcher often does that. That I quote Brian, I have a good footnote. I quote Gilbert, I have a good footnote, and so forth. But I'm not coming forth behind this paywall or behind this firewall of academic minds to then say, okay, as Brian, this is what I am saying. So it is important that as you write, try to identify your voice. After having read all those people, what is your own deduction? What is your own appreciation of what they have said? And this usually has to come up really well. So those are my few provocations. I hope I make sense. I think I'll then hand over back to Kibet or to, and then we'll listen in the next 9 minutes if there are any questions. Thank you.
So thank you very much. Thank you very much, City, for that presentation. I believe that marks the end of the presentation of myself and Sydney. Ordinarily, in such a context, I'd respond, but thank you. So back to you, Paula. Asante.
Thank you so much, Kibet and Sydney. Kibet, I must say the memes in the slideshows were so unexpected. I never expected law students to bring in some touch of humor in their presentation. That was so creative of you, and thank you so much. At this point, I'd like to welcome any questions from the audience. I see, I don't want to mispronounce your name. You're Emoit. Emoit, please go ahead. And yeah, if you have any question, feel free to raise your hand. You can also do it in the chat box. You can also type your question. We'll read it out. Okay. Emoit?
Oh, okay, thank you. Just confirm if you can hear me. I had some network issues.
Yeah, loud and clear, loud and clear.
Oh, thank you. Okay, first of all, I would want to really appreciate Tibet and Sydney for this particular session. I admire how vast in knowledge and understanding they have, articulated these particular subjects, and I really appreciate you for that. Um, so I have about two questions. The first question is, and that is for any of you, you can respond to this. Um, like with the advent of very numerous AI tools, we have the Quillbot, we have this famous one, ChatGPT. So, what is the place of these tools for a young researcher, a legal researcher? How can you use these tools to make your work as more effective as possible, without affecting or rather diluting your original work? You understand? And then the second question goes to Sydney. You talked of historicization of a phenomenon. Yeah. Um, how much of history, like how much of history does one needs to uh, um, go back and incorporate, or rather try to explain a phenomenon? Because I've had this challenge where um, I've identified maybe a sub question of my central claim, and yeah, I decide, okay, let me go and study a bit of history about this thing, and I start to explain, and then I kind of realize I'm drifting from the central claim, or rather from the research question. So, how much of explaining, or rather history, do you need to like attach to a sub question? Yeah. So I think that those are my two questions. Thank you.
Sorry, Paula, just to come in here, realizing that you're almost on time, is it possible to just get all the questions and then Brian can have a round and then I'll have a round and then we'll hand it back to you. Are we still here? Yeah, so I think you can do that. I think there was a question on theoretical framework. Maybe Abby can ask and then Muthoni can ask, but you can just keep it short. And then anyone else who has a question can follow suit. And then we'll just have Brian answer. And then I'll answer the questions also collectively. So maybe Abby and then Muthoni, and then just like short questions, we'd really appreciate.
No, mine isn't really a question, but I'd like you guys to comment about the theoretical framework. You can just say something short about it.
Okay. Lawrence?
My question is a pretty interesting one. I hope I'll be given the chance to explain it. Hope I can be heard.
Clear.
So, what is the place of confusion in a research, maybe a research project? I have done several moots in areas that maybe haven't studied before in class. And interacting these materials, maybe you're going to find others talking about peace, others disagreeing, others agreeing in some parts, disagreeing in such. And at times I may be lost in those arguments and disagreements. What's the place of that confusion in a research?
Sorry, just come again. Sorry.
Okay. My question is, what is the place of confusion in a research project? And a background of this, I've done several moots and maybe in areas that we haven't studied, so I don't have background knowledge. And I'm going to get articles that on one hand they agree with this position, disagree with this, other articles disagreeing with this position, agreeing with this. Some agree partly and disagree partly, and in the end you may find yourself confused. So what is the place of that in writing or maybe researching?
Maybe Sydney, could I go first, seeing that there are no other questions?
For sure.
Absolutely. So I'll begin by tackling the question asked by Emoit, which is here's to the advent of AI. What's the place of the same? What's the place of the same in legal research and the like? So one thing that you'd have to look into, at least with the information that we have today, is that AI is generally, it is yet to attain the level of having general, like we don't have general artificial intelligence. That is, it does not have feelings and the like. It's not able to take into context, the social context and the like, within which humans continue to have a hand in the same. However, its role should never be wished away, and it can be utilized. Actually, I do use some of those artificial intelligence tools, and it's actually something that you can't afford to not to use, but you have to use it in a good way. And in a good way, by this sense, means you use it to collect sources, you know, like if you'd like to read, particularly if you're reading into something that's totally new, like you ask it, you provide questions to it, what are the top works according to what it has, then you use it to find sources on very particular information, so that whatever the prompts that you are keying into JSTOR or Hein Online or LexisNexis, whatever you're trying to look for over there is no longer a long shot as it used to be, but it's more specific. It's also a good way, I believe, to learn how to, like, it could also teach you language, because if some of those prompts are actually very well written, so if you read them and kind of use it to improve your English skills and the like, I think that would be critical. Then Abby asked about a question on theoretical framework. Maybe you're asking what runs through the core of a theoretical framework. And the core essence of a theoretical framework is to find the place whereby whatever you are trying to say, how can it be theorized? For instance, somebody is arguing something on, you are writing a paper on police brutality, for instance, and as Sydney had pointed out before, it appeared, at least it appears like some certain section of the population is affected more than the other, and you notice in the process of carrying out your research that is actually the poor who are getting affected more than the others. So you can look into the same and say that the theory that could explain or has been put out before to explain this particular issue could be the Marxist Leninist, that you say that the law is being utilized to harm the poor. So that's how the theoretical framework generally looks like. So you tweak into whatever you've been taught in your jurisprudence class, for example, utilitarianism, whereby everyone is trying to maximize on the best good of the society. So which theory could explain that was theorized on the same? For instance, yes. So for instance, you are working on something such as effective altruism. That's about doing the most good in the society. What could explain that? So you go to a field such as utilitarianism, which is a theory that says everyone is trying to be the happiest. So that could explain why people are doing that. Generally, it's that which has been put forward to explain that which you are trying to say. If you can get whatever I'm saying, it's a bit clumsy. Finally, to Lawrence, confusion in a research project, you don't I don't think that's really confusion per se, because if somebody else is saying this and for this reason, someone else is saying that for their own reasons, it all boils down to what are you saying yourself. So you say, because you have a research question or conceptual framework in your head and you know why you are saying that. So you say, this guy has said this and this. However, I disagree with him for these reasons and say this. Somebody else you agree with, you say, yes, I agree with him to the extent that these claims go 1, 2, 3. However, given what I'm saying is this, for these reasons, whatever has been said before, I'm discounting the same, I'm agreeing with them, but for a different reason. So it's a whole, it's not really, you wouldn't really describe it as a confusion, but you find yourself in the maze of what really research is all about, particularly in the social sciences. Thank you. I hope that answers some of your questions, Sydney.
Okay, thanks so much, Brian. Once again, my work is easier. So for AI, I hold the same opinions as Brian. Use it. I use ChatGPT a lot. I don't think I do any research without engaging ChatGPT. Pay for the paid version, it's like $20, I think. Yeah, so I mean, use it a lot. It helps you in articulation. It can critique your argument. So it all depends on the prompting. Go on YouTube. Let me share with you a profile. I've shared with you a profile of somebody who's like really looking deep into these AI tools in helping you to research. I've just shared it in the chat. Go deep. Go on YouTube. Find out. The key is prompting. How are you prompting this chatbot to help you give you the correct responses? If you don't ask the right questions, and you know this in research, you will never get the right answers. So it's always about the right questions. So the most basic thing for me is I would type a paragraph, or I would write an abstract maybe for a conference, and I would ask ChatGPT, assuming you are a human rights whatever, or you are a trade scholar who has read 1, 2, 3, 4, 5 books, critique this abstract, or or something like that, or even the most basic one is you have a very complicated paragraph, you put it into the chatbot and you ask ChatGPT to simplify it to you or to write it for you in a certain way, and it does that really well. And then now you edit and you make it look better. So for me, I think the place of AI is those who jump on it really, really early on and use it and really master how to use the prompts and develop with it, because it's an interactive tool, meaning it's learning. I think will always have an edge over over the skeptics. So the early adopters will always have an edge over the skeptics. In my opinion, again, I'm not an expert, but it's just my opinion. On how far we need to go in history, this is it's a what I would say, it's a lifelong pursuit. I would, what is reasonable for you? What are the people who have studied this? And so what I would say is, look at How Europe Developed Africa by Walter Rodney. He has something about historicization. Read Suzanne Marks' article on root causes. She has something about historicization, although she doesn't call it historicization. I'm just typing that. Yeah, so look at those. It will help you to understand how far you can go. But again, it's you develop as you go. As you keep doing this, you keep getting better. So it's not something that you get better within one research paper that you are doing. Over time. By the time you are a mature researcher, after years and years of experience, it will become much clearer to you. The second last question on theoretical framework, what can I say about theoretical framework other than what Brian has said, is if you've seen the movie Oppenheimer, it's showing now, one of the most fascinating quotes Robert says is, you can only go so far with theory. It can never, even for him, he was a theoretical physicist, I believe, but then to develop the atomic bomb, you have to go to practice in a way. So for me, that's that. You can only go so far with theory. But it's normally a requirement at undergraduate level. At this level, I don't do that anymore I don't know, but at undergrad, it's a requirement. So Brian is more advanced to that, more advanced, more informed on that. The last question is the place of confusion, eternal vigilance. Yeah, it's trial and error. If you read Abisab's, thanks Kibet, Abisab's paper called something about behind enemy lines, Georges Abisab, behind enemy lines, he'll tell you that some of the really, really fundamental doctrines that you develop as a researcher are born out of trial and error, and then through trial and error, you're able to establish that pattern. You're able now to solidify your ideas. So yes, get confused, read further, keep reading, get confused. After some time, you will be able to develop this acumen to, to tell the good from the bad. So yes, thank you very much, guys. I really appreciate this. Yeah, pleasure. I've seen Mohammed has asked a question, Mohammed Farah, but that's more for the law journal. I'm sure you guys will respond to him. Once again, it was a pleasure to speak to you. Hopefully, you can invite me again.
So thank you very much, Sydney, for that. And I was equally humbled to join in this evening and share the little I know. I look forward to more of such interactions. And if you invite Sydney next time, I'd be more than ready to join in as his discussant, because I've seen nowadays he appears to be my discussant. So when you invite him as the main speaker, kindly consider me, Natasha Upola, as the person who's going to be responding to whatever he's going to say. Thank you very much, and back to you, Paula.
Thank you so much, Kibet. We'll make sure next time you are attached to the You're attached as one of the speakers. Very much. Thank you so much. I've actually learned a lot, and I'm sure I'll be reflecting on a lot. Um, Now, as your moderator today, I've had the privilege of witnessing two brilliant minds in action and guiding us in an enriching journey, and I couldn't be prouder of this collective progress and dynamic energy. And I'm definitely looking forward for a second season, a third season, a fourth season of you guys enlightening us on how to do better in our legal research and writing skills. And for matter of fact, the first group of speakers who have embraced technology, who have oftenly confessed to using ChatGPT, to using these apps that are often frowned upon. And I think that's a positive step in the legal and research writing field. Now, at this point, I don't think it will be fair to close the meeting without having us have a word from our very own Madam Chair, Natasha Kahungi. I'll let you say something.
Good evening, everyone. I hope I am audible. Am I? Thank you.
Yes, you are, Madam
Thank you.
Chair.
Thank you, Paula. Thank you so much, Sydney and Kibet, for the training. I have learned a lot, especially the part on the conceptual framework. I think that's one bit that I haven't quite grasped in my legal research career. And yeah, I believe in learning something new every day. So this counts as the new thing that I've learned today. I hope everyone has taken away one or two things. And I also hope that you guys will implement what you have learned in our blog. For those who are in the group, our blog is linked to the WhatsApp description. For those who are not in the group, I shall link the same on our LinkedIn page, so you can go and follow us on LinkedIn. We also have an account on Instagram for people who are on Instagram. For people who are on Twitter, our Twitter warriors, we also have an account on Twitter, so go follow us there as well. We have other projects other than, of course, the research training and the blog, which we shall be unveiling very soon. So I hope that you guys will keep in touch. Yeah. Thank you so much, everyone. I'd like to close the meeting. See you next time. Bye.